Rachel Plzak joins me. Rachel Plzak joins me from Travelers Insurance. Rachel is an associate claim executive with Travelers, and Rachel and I have been doing the claim webinars, I think, for the past 5 or 6 years, right, Rachel?
That sounds about right. Yes.
Yes, welcome. Thank you for joining me today.
Thanks for having me.
Yes, it's very exciting. We have some great information to share with you all today, and thank you all for joining us. We're going to be going over some new claim trends that Rachel has seen over the past year happening across the US and discussing some information that can help people in the claims world navigate how to report claims, how to get the best information and the best guidance regarding claims. So we have some really great information to share with you today. And Rachel, I know you're up in New England. You've just recently moved to a new location in Massachusetts, not too far from where you were before, though.
No, I moved about 3 miles, but still a colossal undertaking nonetheless. So,
Yes, moving is always a treat, always a
oh yes.
absolutely. Well, the good thing is you did it before winter got, really.
Yes,
Mhm,
absolutely.
yeah, although it is fall and getting a little chilly, I've heard.
Yeah, I'm getting used to raking leaves now. It's great.
Great
Anyways,
exercise.
yeah.
And great, anyway, we have our disclaimer on the screen, so please take a moment to read the disclaimer. And then we're going to move on to talking about our goal a little bit more, Rachel. You and I have been talking prior to today's webinar. You to go over what you've been seeing, what you've been hearing regarding claims. So we're basically going to talk about the top claims trends that are affecting community associations specifically, and that's your expertise.
Correct.
Great. And I did want to mention a couple things. If you have any questions about what we go over today, feel free to email me. I'll give out my email a few times during the webinar today. It's sherry.branson@amwins.com. Sherry is SHERRY.Branson, BRANSON @amwins.com. Feel free to shoot me an email if you have any questions. And if you'd like the presentation, a copy of today's presentation, I'm happy to email it out to you. And I put the recordings of all of our webinars on our website, which is kdisonline.com. So you can listen to today's webinar and all of our past webinars. So today, Rachel, as I mentioned, we're going to talk about, the top claims and trends that are affecting community associations. Can you help us in defining what is a D&O claim?
Certainly. The screen up right now is the definition of a D&O claim. The first being a written demand for monetary damages or non-monetary relief. The very last sentence there, against an insured for any director's and officer's wrongful act. So what that first one means is it does not need to be a lawsuit. It can be an email. It can be any number of correspondence where there is a demand either for monetary or non-monetary relief and an allegation of a wrongful act. Secondly, we have civil proceeding commenced by service of a complaint. That is what most people think of, a lawsuit. Third, we have a criminal proceeding commenced by the filing of charges. We don't get too many of those, but occasionally it has happened. A formal administrative or regulatory proceeding commenced by a filing of charges. That is your HUD complaint, ADA complaint, EEOC, anything where there's an investigator coming in to investigate the charge of discrimination. 5, we have an arbitration, mediation, or similar alternative dispute resolution proceeding if the insured is obligated to participate. It's probably a good time to have an attorney representing you and in the room with you. So good to turn that in as it is a claim. And lastly, we have a written request to toll or waive a statute of limitations relating to a potential civil or administrative proceeding. That's usually a pretty good indication that an attorney is gearing up to file a lawsuit and afraid that they're going to toll the statute of limitations. So you can kind of see it coming down the pike, and better to get in front of it than to wait. So.
Okay, great. Thank you for that information. So that's the definition of a D&O claim. And we're going to get into the trends that Rachel is seeing and also the common claims that community associations face on a regular basis. So here are the 4 topics that we're going to be covering today. D&O claim trends, as I mentioned, common claims examples that she has seen throughout the years, common policy exclusions, and then the risk management helpline, which is a great tool and resource for your customers to use if they have any legal questions surrounding what is a claim or any legal concerns at all. And we're going to get into helping you navigate the claims world a little bit by defining where your customer should go for each claim question that comes up. So now we'll go into the D&O claim trends, which is, these are some new ones, Rachel, which we haven't really seen before, and you and I have not spoken about until we started working on today's webinar. So these are whole new areas of claims that have been cropping up. So the first one that we have up on the screen is the counterclaim as a stall tactic to litigation. Can you explain what is that?
Sure. So the counterclaim as a stall tactic is not so much a type of claim as it is an attorney's tactic in litigation. And I can give a quick example. We had a person who purchased a number of properties and then stopped paying assessments, and the association filed litigation to collect the assessments, and the owner filed a counterclaim challenging the association's authority to assess them or charge them, send fines, file a lien, file a foreclosure. And that was a process that started in 2012, and it is still open to this day. It has resulted in 4 state court actions, 3 bankruptcies, and multiple appeals. And so they have staved off an inevitable foreclosure for 10 years.
10 years. Wow, that's incredible. That is a lot of stalling. That is a lot of stalling. And I know we had talked prior to the webinar that the association has won each step of the way, correct?
Correct. Every time they've gone in front of a judge, the judge has sided with the association, and yet incredibly frustrating situation for them.
Mm-hmm. Absolutely, and can get very expensive.
Correct. Which is a good reason to have D&O coverage.
Yes, a very good reason to have D&O coverage. A 10-year stall is a long stall, and it can get very expensive. So excellent reason to have D&O. Okay, great. So this is a trend that you're seeing, unfortunately, which is happening right now in the community association industry. And then the next area that you wanted to discuss today is short-term rentals. And I was just going to mention from our experience, what we saw during the pandemic was a lot of associations were restricting them or actually stopping them altogether because they didn't want people coming and going out of units when there were quarantines going on and all kinds of restrictions and things like that, even though the CC&Rs allowed short-term rentals. The board decided to stop them for safety reasons, for health reasons. So, there was that going on where boards were changing the rules to fit what was going on in the world, but the CC&Rs allowed it, so there was conflict there.
Correct. And later on, we're going to talk about violation of CC&Rs, but yes, that would be an example of that where, do you follow the CC&Rs or do you follow the CDC guidance? Can always ask your general counsel what the best course of action would be. That would be my advice on that. In terms of short-term rentals, I love the woman swimming. I like that idea after raking all day. What I want to really emphasize is that by engaging in the process of short-term rentals in your association, it creates a risk of a higher standard of compliance with the ADA. Anytime you're inviting the public in and there's a common area where they're supposed to be able to enjoy, it needs to be ADA compliant or they risk getting hit with a discrimination lawsuit. And so it's very important to understand that you might be undertaking that risk. In addition, that should there be a finding that it the area, whether it be the pool, access to the golf course, whatever, that it is not ADA compliant, then it is on the association. They're responsible for paying for the change in that to make it ADA compliant.
And I would think, like you said, with more people coming and going out of rented units, you have much more traffic in a condo association. So the chances for these types of claims to crop up or come up are it's much more, more of a possibility, much more of a possibility.
Correct. It increases that exposure.
Absolutely. Absolutely. Okay, so short-term rentals is one of the trends that you're seeing. And then I would like to mention, again, if you'd like a copy of today's presentation, please send me an email to sherry.branson@amwins.com. I'm happy to send you a copy, and I record all of the webinars and put them on our website. Okay, now we're going to move on to the next area that we'd like to talk about today, the next trend. Now this one I've read about in the news, I have to admit, the deconversion trend that's taking place. How is that causing problems though in the community association area?
Okay, so deconversion termination is when somebody wants to change the status of an association and basically have it be just private ownership. Where we see issues is when somebody wants to come in and deconvert association and owners don't want to sell, or they feel like they're not offering them enough money. And so they don't sell. And then
Now,
you get.
Can I ask a question? Deconvert. Now, what exactly does deconvert mean?
So a deconversion is to basically undo the process of making it an association.
Okay.
So sort of reverting back to what it was before it was an association.
Okay, so just a regular building that could be used for commercial reasons or residential or whatever you want to convert it to. Okay.
Yep. And most importantly, it is not run by a board of directors, and it does not have governing documents saying what can and cannot be done. So once somebody comes in and they get enough of the shares or enough units where they have a greater voting power than other people and have such an influence that it basically they're in charge of it, that becomes very troublesome. The claim that I saw or handled as a gentleman who purchased a number of units. It was an area of town that was sort of up and coming, but was still it was on like the verge of being gentrified. So everything was still the land was cheap to buy and required some, curb appeal. So he came in and bought a few units initially with the idea that he was going to run a business out of them. That business was subsequently shut down and he was left with empty units in a place where he didn't want to live. So he realized that he could capitalize on his investment by purchasing all of the units, deconverting it, giving it a remake, and then when the prices went up, selling it. The problem was there were people who lived there who didn't want to sell. And it got to the point where he basically owned almost all the units, had full control of the board, and started passing very large assessments, knowing that the owners couldn't pay them, and was planning on foreclosing on them so that he could get control. And before that happened, the owners got together and filed a lawsuit against him and the association. And that's where Travelers came in. And that claim eroded the entire $1 million policy. And at the time of the exhaustion of the policy, it had not resolved yet. So they are incredibly lengthy, expensive, and emotionally driven.
Yes. Wow. Okay. And I've been reading more and more about them all over the US, that it's happening everywhere, basically. And
yeah, I mean, I think developers are starting to realize that the land is worth more money if
Mhm.
they can sell it individually and not as an association. So
Mhm.
they're realizing that it's more profitable if it's deconverted.
Mhm. And I know you and I had talked, prior to today's webinar about looking at the CC&Rs to protect an association. The way an association can potentially protect itself is by looking at their CC&Rs, correct? And
Correct. I mean, and I would recommend that you work with your general counsel on that, and explore if there's a way to amend the documents that would, if it's possible, to prevent one entity or person from owning a majority, so that no one person can take full control.
absolutely. And then we also talked about the LLCs, but that's a whole other issue. Like you've seen situations
Correct.
where, yeah, a person can open multiple LLCs and go into purchase. So there's a lot
Yeah,
of things
they try to
association can,
circumvent. They try
yeah,
to circumvent that rule.
right.
Yeah.
hmm Okay. So there's a lot for the attorneys to think about that work for associations and for associations to think about when it comes to the CC&Rs to protect them from situations like this and having a takeover, so to speak, of their association. Okay. Thank you very much. That's another trend. And I'll just take a moment here to give my email address out again. It's sherry.branson@amwins.com. And if you'd like a copy of the presentation, please send me an email. And now we're going to talk about the common types of claims, Rachel, that everybody's seeing. And you and I've talked about these some of these categories before. Breach of fiduciary duty, which can take many shapes and forms, as you and I have discussed. We have a situation, a claim here that I present on the screen. A board president hires a friend to do the landscaping for the association, even though his friend's company is more expensive than the other bids that came in. I'm sure you've seen situations like that and similar situations. So let's talk about breach of fiduciary duty a little bit and what types of
Sure.
shapes that takes.
Sure. So it takes many shapes. When a person is elected to the board, they're essentially taking an oath to make their decisions in the best interest of the association, not in theirs, not in their friends, not their families, but the best interest of the association. Anytime somebody disputes whether somebody made a decision in their best interest or their families or friends, they can file a claim for breach of fiduciary duty. And I've seen claims where the board is alleged to have made sure that all landscaping and sprucing up, their homes are completed first and then the rest are done. Certainly this one is a good example. Someone hires a friend, not unusual for someone to, have their son do the lawn care or something. So, you
hmm
know,
hmm
it's any time someone is alleged to have made a decision that is not in the best interest of the association.
Okay. And they're making decisions about everything all the time, the board members,
Correct.
about many different topics. So this is why this particular one is very common. And you can see many different claims coming in on from all different areas. Okay. And I see a couple of questions have come in. I was just going to mention that we are going about 40 to 45 minutes today. So if you wouldn't mind emailing your questions to me, I can answer your questions via email or I can give you a phone call. My email again is sherry.branson@amwins.com, and I'm happy to answer your question in an email. Thank you very much. And now we're going to move on to the next common claim that you see, Rachel. Let's see. Here we go. Okay, CC&Rs. Okay. Now this, we see lots of claims coming in regarding violation of CC&Rs. A lot of homeowners unfortunately don't read the CC&Rs, so they're not even aware, that the board might be violating it. But here's the situation on the screen, which you and I have discussed before. There was an election of a new board, and they discovered that the old board had violated the CC&Rs by not meeting the requirements of 2/3 unit owner attendance to pass a vote. So this claim was an example of a violation of CC&Rs and insured versus insured. And what came to mind, we were talking earlier about the during the pandemic, associations had to adjust quickly to what was going on in society and the world. So they were holding virtual board meetings. Everything was virtual. Everything was just put on the Facebook page or email, and no face-to-face contact. So that created, and of course the CCNRs say that the meetings have to be held in person, et cetera. So what are you seeing there?
Right. So the CCNRs will typically say it needs to happen at the clubhouse. The CCNRs are going to set forth how everything should be run. It's basically the rules and protocols in place for how elections will happen, how often, how many board members, how often they need to have an audit of their finances. So it's like the rules of how everything is run. And the CCNRs tend to be pretty specific, and a lot of them will say that the election or meetings will be held in the clubhouse, because that's typically a meeting place that everyone has access to. During the pandemic, when the CDC was, giving guidance and saying no one should meet in public, people pivoted and they had their, Zoom meetings so that they could try to keep business going as usual. And I got a claim where someone complained that they couldn't access the meeting as per the CCNRs in the clubhouse. So even though it didn't really make sense to force everyone to get together in the clubhouse, it was a violation of the CCNRs, and somebody was upset enough that they decided to include that in their complaint.
Incredible, just incredible. And you and I were saying that, that's why D&O is needed, really needed, because many times board members have to make decisions that whichever way they go will turn into a claim, whichever
Correct.
decision they make.
Yeah,
They're
there's
following state
there's
laws, federal laws,
right,
and and then the CCNRs haven't kept up with the changes. The
right.
staff.
So
Mhm.
it's not that there's I think what I was saying was that there isn't a decision they can make that wouldn't leave them exposed to a claim.
Mhm,
Like
mhm.
somebody, you can't please all the people all the
All the
time.
time.
Essentially, that's what
Exactly.
that boils down to. Someone can
Right.
be upset about anything.
That's right. Exactly, exactly. Okay, yes, this is a very common area that we see lots of claims in CCNRs. And I see more questions have come in. Thank you so much for your questions. If you wouldn't mind just sending them to me in an email at Sherry, SHERRY, .branson@amwins.com. And I'm happy to email you or call you when the webinar is over. Thank you. And now we're going to move on to the next topic, the next claim, which we've talked about quite a bit in the past, the breach of contract. And, Rachel, they're signing contracts, associations are signing contracts with landscapers, with painters, with all kinds of vendors every day. And we saw a situation where an association hired a landscaper for a 3-year contract, and they fired them after 1 year because they weren't happy with the work. So the landscaper sued them, and it, if they're breaking the contract in the incorrect way, the non-legal way, then they can lose.
Correct. Correct. If they, there's any contract is going to have a protocol for termination. And if it is not followed, despite the reason for the termination, you did a terrible job, you didn't show up, you didn't, if you don't follow the protocol for how the termination is supposed to go, it lends itself to being a claim for breach of contract. I think I've said in the past that, it's not uncommon to have a new board come in and want a clean house, and they want, new landscaper. They don't like the way the old one was doing things. And so they've got this other person they want to use. And so they fire the one they don't like and bring in the one they like. And then they get a lawsuit because, the contract said that they were supposed to provide 30 days notice to cure, or they were supposed to give 60 days notice that they were going to terminate, and that procedure wasn't followed. I highly recommend, because as you mentioned with the CCNRs, which is the covenants and restrictions. There's two. I'm sorry. I know this is what this one person did ask, CCNRs, but essentially it is the document that sets forth how things will be run in the association. That I've lost my place.
That's okay. The
I'm
rules,
sorry.
the rules
The
have.
rules and regulations. Yeah. So, they expose themselves to litigation. And the thing to note is that if the court were to say that it was done improperly, that that burden is on the association. That is not an indemnified loss under the policy. Oh, I think I was trying to say that the contracts are about as much fun to read as the CCNRs. So it's good to have your attorney look at those over so they can give you guidance.
Absolutely, absolutely. So if in this scenario, if the landscaper won the lawsuit, then the defense would be paid, the HOA's defense would be paid. But if they, let's say, won the final 2 years of the contract, the association would have to pay that themselves.
Correct. That would be an exposure for the association, as well as if there was an award of attorney's fees. That would be, that's not indemnified either.
Okay, the association would have to pay for that. Okay. Okay, so breach of contract. And, as Rachel mentioned several times, speak to your attorney, the association attorney, to get advice, because, when you read these contracts, they're very long and very complicated and lots of legalese. So rather than risking a claim like this in a lawsuit like this, it's better to get legal advice when you're dealing with contract situations. Great. Okay, that's breach of contract. And we see lots of those. And now we're moving on to a discrimination, which really comes in many different shapes and forms. There's so many different types of discrimination claims out there. We saw a situation where an association member filed suit against the association and the board president, saying that they refused to let this person have an emotional support dog. They tried to mediate the situation several times, but they could not agree, and it ended up going to trial over an emotional support dog. So I know this is, we've been talking about this particular emotional support dog trend for quite a while, but discrimination really can take many, many different shapes. What are you seeing there, Rachel?
Sure. So, you can have familial, you can have discrimination if there's different requirements for the pool use based on if someone is in diapers or whether their knowledge of swimming. If you try to have it be a different circumstance for one population, then that can open the doors for a discrimination complaint. I shared with you that, and this is another example of how the board is really just put in a situation where either way they were going to get a complaint. There was a new owner who purchased a unit in a no pet building and made the request for an emotional support animal. The board had to say no because the board knew that the person who lived across the hall from this new owner was deathly allergic to dogs. When she found out about the request, she was able to provide documentation from an allergist and a doctor substantiating that she was deathly allergic. But we had to wait until the owner made the complaint for discrimination before we could really do something. We had a defense counsel already engaged, and they were able to talk with the investigator and explain that there was some extenuating circumstances here. And one of the few times that I've actually had the investigator come back and agree with the association and not allow the animal. But that is really few and far between when that happens.
Very
But
rare.
that's an example though of the board really, they couldn't say yes to both. So
Yes, yeah. So many people now have emotional support animals. They're getting more and more, and some are getting multiple emotional support animals, which is another situation we claim we had talked about with, I think there were 8 dogs or something.
Yes, that
Mhm.
was yeah, in New York
Uh-huh.
City.
In an
So you can
apartment,
only
not
imagine.
a house, an apartment.
Yeah. Yeah, I believe that was she was claiming that 7 of them were support animals. So
7. Wow, that's a lot of support. Okay.
that's a lot of support. But
And if the CCNRs don't have a limit, if they don't talk specifically about the limit of animals or emotional support animals, it's I don't they don't have any restrictions in place. Somebody can
right,
argue that, can
they
argue
might be
against
able to push that limit.
to a dozen maybe.
Yeah, right.
Well, great. Okay, that's discrimination. As Rachel mentioned, can cover a lot of different areas. It could be a flag in front of a house. We've had people I know wanting to put flags out that they were told to take the flags down and they were upset about that, or even painting their houses a certain color, that has come up as well. So lots of areas of discrimination for people to be aware of and for associations to be in tune with and to be aware that anything can really trigger this type of situation. And now lots of associations, Rachel, have employees. They have some will have just a couple employees and some have many employees depending upon the size. But employment practices liability is another area that we've seen lots of claims, and I know you have. We saw a situation with a condo association where they had an older employee in his 70s. They terminated him. They hired a younger person in his place, and he basically sued for age discrimination. And because this particular association had more than 20 employees, it's subject to the Age Discrimination in Employment Act, which is the ADEA, which means that's a federal law. And so basically, they violated that. So there's a lot for, board members are not HR professionals, human resources professionals. There's lots of laws that cover employees and cover how you handle situations, terminations, etc. So what have you seen there?
Um, so I just want to point out that this is another example of discrimination as well as being an EPL claim.
Mhm.
So this would be age discrimination. So I mean, just to sort of point out that it really can come in many forms. So yeah, what I want to say is that I think if you're going to have employees in an
Mhm.
association, that it should be mandatory that you have an employee handbook. You want something that sets forth what the expectations are and what the consequences are for not meeting those expectations. In addition, document, document, document.
Mhm.
When
Mhm.
somebody is not doing what they're supposed to do, document it.
Mhm.
I had a claim years ago where it was a doorman. It was in New York City, and he claimed improper termination. And the building had video footage of him sleeping with his feet up on the counter. And that, was
So
some
that's good
really good
evidence. That's
evidence
good
for the
evidence. You're
investigator.
talking
Yeah,
about
that's some
documenting
great
and
evidence.
mhm,
Most people don't have it. So you
right,
need to write down and document everything that's happening, because evidence is not your opinion. You can't say,
right,
I don't, he doesn't do a good enough job. She doesn't do enough. She's
right,
lazy. He doesn't, incompetent, whatever.
right, right.
You gotta write it
That's not
down.
going to do any good.
Yeah.
Hmm. Hmm. So document the problems with this particular employee and make sure it's in writing and in a
Yep.
file and
Substantiate. If you're going to terminate based on a reason, you need to substantiate it. You need to have the evidence. Also, talk to general counsel before
yes,
you do it,
yes,
so
absolutely.
that you don't, you have a great reason to, but you do it improperly, and that nobody wants to do that.
No, no, absolutely not. It could get very, very, very difficult and expensive and be a big problem. big problem. So speak to counsel, absolutely. So you're doing it properly. And like we said earlier, board members are not human resources professionals. They don't have that background. So, and this is there's lots of laws covering the field of HR, of human resources and employees. So, okay, great. And now we're going to move on to the next slide, which is now we're going to talk about exclusions, Rachel. And these areas, we do get, submissions for claims that actually they're not covered under the D&O policy. So what are the common exclusions that you'd like to share with everybody?
Well, the two sort of most obvious ones is property damage and bodily injury. The D&O policy has a very broad exclusion for these types of losses, and that's by design. That is a loss that is typically covered under your general liability policy, and it really wouldn't make sense to have duplicate coverage and to be paying more premium for coverage that you already have. And the other factors that can result that could result in a denial is late reporting being one of them. As I mentioned at the beginning of the webinar, the administrative complaints, your HUD complaint, EEOC, ADA, I've had several situations where people have looked at that, thought, oh, I can respond to that and I'll just draft it up and I won't have to file a claim. And then there is a cause finding, and then the state can file a complaint on behalf of the complainant. Once it gets to that point, if it's tendered to us, that likely would result in a denial for late notice, and also because we would be prejudiced in our ability to defend it. And the second one there, claims made versus occurrence. There's a difference between CGL homeowner auto policies, where the claims made date is the occurrence of the loss, versus under a D&O policy, the claims made date is the date that the insured became aware of the claim, the lawsuit, the mediation, the email from an irate homeowner. So if somebody doesn't understand that, a policy could be canceled, but the alleged wrongful act happened, back in the policy period, and they think that would trigger a D&O claim. But if our policy is canceled, then there's no coverage for the claim. I hope that was clear.
Yes.
Okay.
And if anybody has any questions, regarding claims made versus occurrence, please send an email. I'm happy to answer them. Rachel and I are happy to answer them and clarify it. Yes, that made sense. And then, Rachel, we get a lot of questions about various topics. I do, and you do, and a lot of people at Kevin Davis do as well. So if there are any policy related questions, we just wanted to clarify that we can help with that. Rachel can help with that. Travelers can help with that as well. And then we wanted to just help the next slide that comes up. We're going to talk about risk management. This is an area which is a great resource and a great tool for insureds. And basically it's a hotline or helpline, I should say, from Monday through Friday, 8 to 5 p.m. Eastern Standard Time. And the phone number, I'll read it out loud, is 855-548-8656. This is basically free legal advice from the law firm of Cole, Scott, and Cassane. You can call with any legal questions related to your association. It's a great resource, a great tool. So feel free to give it to your insureds if they have a traveler's D&O policy with us and they are able to get their legal questions answered. They get 1 hour for free. So it's a great resource. So that's a risk management helpline. And then on the next slide, we're going to talk about just kind of helping people, navigate where to go in the claims world. So we talked about the risk management helpline already, which is legal questions. If you have policy related questions, Travelers or Kevin Davis Insurance can help. We're community association experts, so we've been working in the community association field for many years. And if you have any questions about whether something should be submitted as a claim, please contact your agent. So if you get a complaint, you get an email from somebody and you're wondering, what do I do about this? Call your agent and your agent can advise you on where to go and whether you should submit it as a claim. And now on the screen, I have the claims hotline, which is on each policy, on each D&O policy. It's where the claims are actually submitted. It's 800-842-8496. And then Rachel's been working in the claims area for many years. She's a claims expert. Travelers has fantastic claims experts working at the company, and they're the best in the business, right, Rachel?
I would say so. I
Yes,
might be biased,
a little biased.
but I think my colleagues are the best. So
Travelers is the best in the business. They're
that's
great
my opinion.
getting a quality company and quality people and great experts. Rachel
And
is
underwriters,
and
absolutely.
underwriters. Yes, absolutely. And we work with travelers, obviously, and we're experts in community associations, so we can help you out there as well. So, well, thank you very much, Rachel. Thank you very much
Absolutely.
for your expertise today and the excellent webinar. And thank you for all of your questions, everybody. I see the questions have come in. Again, I'll give out my email one more time. It's Sherry, SHERRY .branson@amwins.com. Please send your questions to my email and I'll get back to you to answer your questions. And the recording of today's webinar is going to go on our website, which is kdisonline.com. You can listen to it again. And if you'd like today's PowerPoint, I can also email you that. So thanks everybody for joining us. Have a great day. And thank you, Rachel. Take care.
Absolutely. Thank you. Bye-bye.
Bye-bye.